Did you know that the probate courts in India will only get into the authenticity of the will and not deal with the intention of the testator? Hi, my name is Damini and welcome to Vakilsearch's Real Estate Investment Series. In this episode, we will deep dive into the will probate and learn the what, why, how, who and everything of a will probate. We have in our previous episodes dealt with will drafting and registration. The process of execution of the will is called a probate. Let's learn the basics first. What is a probate? Probate is a legal process that validates a person's will and oversees the administration of their estate after their death. It is an application made before the court seeking its permission to execute the will. You may wonder, why is a probate necessary? Firstly, it is important and mandated by the succession laws in India. Secondly, it serves various purposes like solving debts and taxes of the deceased and distributing the assets of the deceased amongst the legal heirs as per his wish. Next, let's move on to who are the parties involved in a will probate. There are several key parties that are involved in a will probate. Firstly, the testator. The testator is a person who writes the will. Witnesses are people who are witnessing the will at the time when it was written. Executor is a person named in the will to administer the estate. Beneficiaries are those who named in the will to receive the assets. When does probate occur? Probate usually comes into existence on the death of the testator. The exact timing may vary from case to case, but the executor can initiate the process within days or months of the death of the testator. Where is probate mandatory? Probate is mandatory as per law only in the 3 presidency towns in India. They are Chennai, Bombay and Kolkata. But a few regions like Delhi NCR have mandated probate to avoid any confusion. How to obtain probate? The process can vary from state to state and from High Court to District Court, but there are few common steps involved. Let's go one by one. Step 1. If there is an executor appointed in the will, he or she can move the petition for probate before the court. In the absence of the executor, a petition for letter of administration is filed with the court. Step 2. All the beneficiaries and the legal heirs of the deceased are given a notice to receive any objections. Step 3. If there are no objections, then the court fee for the probate proceedings has to be paid. Then the court grants the probate. In case if it is contested, the court will validate the will after examining the evidences placed by the parties before it and then grants the probate order. How long does it take to grant the probate? Usually, uncontested probate take about 6 to 8 months time and contested proceedings can even go on for years together. This is all about probate. If you require any assistance in obtaining a probate or to know more about probate, please reach out to us at www.vakilsearch.com or call us at 7200-365-365. For more exciting videos on real estate investment series, follow Vakilsearch's YouTube channel.